supplement your positions then?
Yes, please. In lieu of them watching the testimony, which we maintain is the best alternative, to allay some of the concerns we have with respect to prejudice, we would ask that an instruction be given to the jury, reminding and admonishing them that a readback cannot reflect the matters of demeanor, tone, or voice in which the testimony was given. So we would ask that the jury be reminded that a readback is not a complete accounting of the testimony because it doesn't account for manner, tone, voice, and the things which they may have observed. So we ask that that instruction be given prior to them getting the readback or after.
Stay with you.
Your Honor, there is a standard jury instruction 4.4 that covers this. That would be the state's position that that's what Your Honor is reading.
Let me take a peek.
Thank you. That's what I typically would do, counsel, to read back the standard jury instruction.
I do notice that that the headings of each one of these speaks to readback / playback. So I do believe that the rules do contemplate a playback as opposed to a readback. Just to correct the record, because my understanding from the state was that a playback was not called for, but this proposed rule does actually mention playback.
Thank you.
Your Honor, also, this Rule 4.4 does not contemplate the issues that are concerning, particularly with respect to Mr. Glass hiding behind the monitor and behind his hair. We think that it's important that the jury be reminded that tone, manner, and comportment during testimony are also important in their assessment of credit. So we ask that not just the standard.
Thank you.
Thank you.
Madam State, anything additional?
Yeah.
Two things, counsel. Number one, my understanding of the readback, playback issue has to do with evidence. It's something that's in evidence that's going to be played back to the jury, not trying to find out something that was live stream, not in evidence, to play back to the jury. I think there's a difference. That's the first thing. Second thing, regarding the witness, my recollection was you said he was hiding behind it. My understanding is you asked him, or somebody asked him a question about it, and he said he was blind in one eye. I thought that was the issue, he was blind in his left eye. But regardless, I'm sure it's in the transcript. But your objection, I'm just going to read this thing. All right? Bring the jury in.
Thank you.
Jury entering. Ladies and gentlemen, thank you. Please be seated. Let the record reflect the presence of the defendant. His counsel, the assistant attorney. I have a jury inquiry form. It says request to view evidence. It states clarification. Courtney Sutherland should have been quote Henry. We have decided we do not need to hear this statement from the hospital. And then it goes on, Trayvon Glass, we would like to have his testimony read back. Michael Kelly, we would like to have his testimony read back when available. So what I've done, ladies and gentlemen, I've talked to the court reporter, and she is able to read back the testimony of Mr. Trayvon Glass at this time. I discussed this with the attorneys, and the court reporter is going to read that back now. As far as Michael Kelly, she's working on getting that done, and as soon as it's ready, we will have it read back to his testimony. So, Madam Court Reporter, could you read back the testimony of Mr. Trayvon Glass, please? Sure. You need to take the microphone down.
The court, call your next witness, please. Ms. Smith, Trayvon Glass. The court, are you ready, Mr. Glass? The witness, yes, sir. The court, welcome. This is our witness stand over here. Once you come to the witness stand, what I'd like you to do is remain standing and raise your right hand to be sworn. The clerk, do you solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth? The witness, I do. The clerk, state your full legal name for the record. The witness, Trayvon Glass. The clerk, please spell your first and last name for the court reporter. The witness, Travonglass. The court, please have a seat. Mr. Glass, that microphone in front of you only adjusts up or down. It doesn't move back and forth. The witness, all right. The court, so if you could scoot up close to the microphone. Ready to proceed, sir? Counsel, you may. Ms. Smith, thank you, Your Honor. Direct examination by Ms. Smith. Question. Good morning, Mr. Glass. Answer. Good morning. Question. I know that you are quite soft-spoken, so I'm going to need you to speak up a little louder. Okay? And remember, you have to make oral responses. Okay? Answer. Yes. Question. How old are you? Answer. I'm 23. Question. And where are you currently living? What city? Answer. Vero Beach. Question. And have you lived there all your life? Answer. Majority of it. Question. Okay. You completed high school, or what was the last grade you completed? Answer. 11th. Question. All right. You're not married, correct? Answer. Excuse me? Question. You're not married? Answer. No. Question. So I'm going to talk about some prior stuff before we get into why you're here today. Have you previously been convicted of a felony? Yes or no? Answer. Yeah. And how many times? Answer. To my best knowledge, once. Question. If I were to show you something, would that refresh your recollection? Answer. Yeah. Question. A prior judgment? Ms. Smith, Your Honor, permission to approach the witness? The court. First, show counsel first, please. Ms. Smith, yes. Question. I'm going to ask you to just look at the document. Don't say anything, okay? Have you had an opportunity to review the document? You have to answer. Answer yes. Question. All right. Is your memory refreshed as to how many convictions you have? Answer 2. Or is that 1? I don't know shit. I see 2 charges. Question. All right. Now you currently have some pending charges in Indian River County, correct? Answer. Yeah. And those are 2 charges? Answer. Yeah. Question. Misdemeanor resisting without violence? Answer. Yeah. Question. And an obstruction of service or execution of a search warrant? Answer. Yeah. Question. Are those misdemeanors or felonies? Answer. I'm not sure. Question. Okay. Do you know what the penalty you are facing on those charges? Answer. No. Question. Have you been offered probation in that case? Answer. Yeah. And have you been made any promises in exchange for your testimony here today? Answer, no. Question, all right. So let's go back to October 26, 2018. What were you doing like for work? Answer, I wasn't working at all. Question, were you involved in the music business at all? Answer, kind of, sort of. Question, and how so? Answer, making beats. Question, all right, and when you were making beats, were you working with a specific group or music group or people? Answer, one person to be particular, but yeah, it was supposed to be in a group. Question, all right, let's start by saying this. What group was it? Answer, in YNW. Question, all right, and when you said one person specifically, who was that person? Answer, Judy. Question, and can you tell the members of the jury Judy's real name? Answer, Christopher Thomas. Question, and how long had you known Christopher Thomas, who you refer to as Judy? Answer, over a decade. Question, and this is back in October. And did you know somebody by the name of Anthony Williams who went by Sack Chaser? Answer, yeah. Question, and how long have you known Sack Chaser? Answer, a couple of years. Ms. Smith, permission to approach the witness with State 73. The court is in evidence. Ms. Smith, yes. The court, yes, you may proceed. By Ms. Smith. Question, Travion, I'm going to ask you to take a look at State's photograph number 4 in State 73. Do you recognize that person in State's photograph with the label marking 18-3118? Answer, I do. Question, and who is that? Answer, Anthony Williams. Question, so back on October 26, 2018, do you recall being at the New Era studio? Answer, yeah. Question, who were you there with? Answer, a few other people. Question, okay, was Juby and Sack there? Answer, correct. Question, all right, and do you recall around what time you guys got to the studio? Answer, I'm not sure when we arrived. Question, was it light or dark outside? Answer, I believe it was dark, I'm not sure. Question, all right, and what was the intention going to the studio? Answer, I believe we were supposed to have a 12-hour session. Question, all right, and that's a 12-hour recording session, right? Answer, yeah. Question, and who was the artist that was recording that night? Answer, it was everybody. Everybody was an artist in that room. Question, all right, did you guys end up staying for 12 hours? Answer, nah. Question, okay, what changed and why didn't you end up staying? Answer, to the best of my knowledge, people was sleeping, so we ended up going home because you don't sleep in the studio. Question, all right, and part of that is because studio time is paid for. Answer, paid for. Question, okay, you just said it was paid for. What was paid for? Answer, studio time. Question, so you guys had prepaid for 12 hours? Answer, correct. Question, I'll move on. How long? Well, you said that people were sleeping. Who was sleeping? Answer, everybody but me, Anthony, and Christopher. Question, was someone upset that people were sleeping? Answer, I guess you could say that. Question, and who was that person? Answer, Sack. Question, and how did Sack respond? How did Sack respond to people sleeping? Answer, he woke them up and let them know it's time to go. And how did he do that? Answer, yeah, he went and woke them up, shook them up. Question, okay, so at some point you just mentioned that guys were getting ready to leave the studio. Answer, yeah. Ms. Smith, publishing State 72, publishing image number 1 in State 72. Question, Mr. Glass, can you see that photo on the screen in front of you? Answer, yes. Question, okay, and who is that person? Answer, to the best of my knowledge, Melly. Question, okay, and the person I'm referring to, what is he wearing? Answer, a jacket. Question, all right, do you recognize the person on the other side of the photograph wearing what appears to be a black shirt? Answer, kinda, sorta. Question, if you do? Answer, no, I don't. Question, publishing image number 2. Do you recognize individuals in that photograph? Answer, 2 of 3 of them, yeah. Question, okay, so what you can do is identify them by clothing that they are wearing. Answer, juvie, black jacket to the left, sack in the middle, jean jacket, Tay, black jacket. Question, and sack, is he standing or sitting? Answer, sitting. Question, and Tay, is he standing or sitting? Answer, sitting. Question, and you said Cortland was wearing a black jacket. Is he standing or sitting? Answer, who? Question, how did you refer to him? My apologies. Answer, Tay. Question, no. Answer, Juby. Question, the person wearing the black jacket, who did you identify that as? Answer, Juby is wearing a black jacket. Also, it's Tay wearing a black jacket. Question, the person wearing the black jacket who is standing up, do you recognize that individual? Answer, that's Chris. Question, okay, do you recognize the people in photograph image 3? Answer, same one you just showed, same person. Question, and who is that person? Answer, Melly. Question, the 3 images that were just shown from State 72, do you recall when those photographs were taken? Answer, same night. Question, what date would that be? Answer, 10/26. Question, of 2018? Answer, yeah. Question, what location were those photographs taken in? Answer, New Era Promotions at the studio. Question, was that the studio we just discussed that you guys were hanging out at? Answer, yeah. Ms. Smith, I'm now publishing State 7, publishing 10/26/2018, beginning at timestamp 2/17/42. Question, Mr. Glass, do you recognize the 2 individuals on the screen paused at 2/17/47? Answer, do I recognize the back of their head? Answer, yes. Do you recognize them? Answer, I just see the back of heads. Question, okay, I'm going to continue to play. Do you recognize anyone at timestamp 2/17/52? Answer, still the back of the heads. Question, do you see an individual standing next to a red vehicle? Answer, yes, that's Kobe. Question, you just said that's who? Answer, Kobe. Question, and what is Kobe's real name? Answer, that's what I know him by, Kobe. Question, all right, would anything refresh your recollection as to his legal name? Answer, I don't know. Question, if I were to show you your prior statement, would that refresh your recollection? Answer, it could. Ms. Smith, permission to approach the witness? The court, you may. Question, Mr. Glass, if you could take a moment and look at this page, read it to yourself, do not read aloud, and look up when you're done. Has your memory been refreshed as to the legal name of Kobe? Answer, yeah. Question, what is Kobe's legal name? Answer, Jacoby Mills. The reporter, I'm sorry, the witness, Jacoby. By Ms. Smith. Question, all right, if you can repeat the last name for the court reporter. Answer, Mills. Question, I'm going to continue to publish State 7. There is a second individual at the red Mitsubishi vehicle. Do you recognize that second individual? Answer, not really, no. Question, okay, how about the individual that is standing at the gray Jeep? Answer, that's Zach. Question, I'm going to continue to publish. I'm pausing at timestamp 2/18/21. Do you see that individual who's walking away from the Mitsubishi Jeep? Answer, I see him. Yeah. Question, do you recognize him? Answer, that's AD. Question, I'm going to ask you for AD's legal name. Answer, I know his last name is Davis. Question, okay. Would looking at your statement refresh your recollection as to his legal name? Answer, I guess so. I don't know. Ms. Smith, you're on a permission to approach the court. Is that the same statement? Ms. Smith, yes, Judge. Approaching the witness. Question by Ms. Smith. Mr. Glass, same procedure. If you could take a look at that and look up. Answer, unintelligible. Question, no, without speaking. Has your memory been refreshed as to AD's legal name? Answer, yes. Question, okay, what is AD's legal name? Answer, Adrian Davis. Question, continue to publish state 7. Mr. Glass, let me know if you need to rewind the video. Did you have a chance to look at the face of the individual wearing what appears to be a white shirt and blue shorts? Answer, that's me. Question, continuing to publish. I'm pausing the video on 2/18/41. Do you see that individual carrying something across his shoulder, wearing what appears to be a blue jacket? Answer, say that again. Question, do you see the person on the video? Answer, I see the back of his head. Question, do you see the back of the head of the person wearing the jean jacket? Correct. Answer, correct. Question, do you see the jacket in state 72, image number 3, the front of the jacket? Answer, yeah. Question, do you see that jacket in state's image 1 of state 72? Answer, I see the same thing y'all see. Question, we spoke about this, Mr. Glass. Answer, I said that. The court, excuse me. Counsel, you ask questions, all right? By Ms. Smith, question. I'm asking questions, Mr. Glass, and just asking you to respond if you have knowledge. Is this the jacket that was in image number 1 and image number 3, the jacket that Melly was wearing on October 26th of 2018? Answer, to the best of my knowledge. Question, to the best of your knowledge, yes or no? Answer, yes. Ms. Smith, publishing state 7. Question, I'm back to state 7, timestamp 2/18/41. The individual that's on screen wearing the jacket, it appears something across his back. Who is that individual? Mr. Glass, can you respond? Answer, I see the same person as last time. Question, okay, and can you tell us who that same person is? Answer, Melly. Ms. Smith, continuing to publish. The witness asking questions I don't know the answers to. By Ms. Smith, question. Mr. Glass, you can't speak when there's not a question. Mr. Glass, do you see that individual carrying something in their left hand? I'm asking you if you see them, just if you see them. Answer, yes. Question, do you recognize that person? Answer, of course. Question, and who is that person? Answer, Christopher Thomas. Question, Mr. Glass, can you identify for the record? I know there's a video, but can you identify which vehicle you got into? Answer, the red Mitsubishi. Question, and can you tell us who was in the car with you? Answer, Kobe, Tay, and AD. Question, so AD, Tay, and Kobe. Answer, Is that a yes? Answer, yes. Question, so that is a total of 4 people. Answer, correct. And in the vehicle to the left of the screen, the Jeep, who entered that vehicle to your knowledge? Answer, everybody else that was there. Sack, Melly, Juby, and Cortland. Answer, okay. I'm sorry, question, okay, and by my count, is that also 4 people? Answer, correct. Question, and when those continuing to publish at 2/19/36, I'm going to stop at 2/19/46. At the time you left the scene in that red Mitsubishi, where were you headed? Answer, supposed to be home. Question, who's home? Answer, I guess Melly's house. Question, and was everybody in that red car headed to Melly's house? Answer, to the best of my knowledge. Question, and what about the Jeep? Where was your understanding that the Jeep was headed, the gray Jeep? Answer, same spot. Question, so both cars left the studio with the intention of heading to what you identified as Melly's house? Answer, correct. Question, can you tell us, I guess, what was the mood or the vibe of the studio while you guys were there? Answer, it was years ago. I can't tell you nothing right now. Question, okay, if you don't recall, that's fine. Was there any physical confrontation that you observed at the studio? Answer, just like a regular day at the studio, smoking and drinking. And you just mentioned smoking. Where are you smoking? Specifically you. Answer, weed. Question, all right. And now the vehicles. We saw that the gray vehicle on the video pulled off first. Can you tell us where you guys, the route you guys took to the best of your knowledge? I can't tell you because I don't know. Do you recall getting on a highway at all? Answer, I recall being in the car while it was driving. I don't know where. I don't know. I don't. Question, were you awake the entire time you were in that vehicle? Answer, I wasn't. Question, okay, do you know at what point you fell asleep? Answer, I don't. Question, all right. And when you left the studio, you were awake. Is that a fair statement? Answer, I was. Question, and at what point do you recall waking up, or what time do you recall the next thing you saw? Answer, once it came to a stop. Question, all right. And where did you come to a stop? Answer, at the house gate. Question, at the house gate for Melly's house? Answer, yeah. Question, when you got to the house gate at Melly's house, who was inside your vehicle, the red Mitsubishi? Answer, same people you seen get in the car. Question, by your testimony, Kobe, AD, Tay, and yourself? Answer, yes. Question, okay, so still 4 people. Answer, still 4 people. Question, do you recall how you guys entered the gate? Answer, the gate was open for us. Ms. Smith, publishing states 47. Question by Ms. Smith, I'm going to pause it at timestamp 349, looks like 58. Do you recognize that red Jeep Mitsubishi? Answer, I do. Question, is that the vehicle that you left the studio in? Answer, yes. Question, is this the guard gate you testified to at Melly's house? Answer, yes. Question, do you see that screenshot at timestamp 351:31? Answer, Question, is that a yes? Answer, yes. Question, do you see yourself inside that red Mitsubishi vehicle? Answer, yes. Question, and were you located? Answer, and where are you located? Answer, passenger. Question, do you recall going through the gate, going through the procedure of going through the gate? Answer, yes. Question, so you get through the gate, where do you go next? Answer, to the house. Question, all right. And can you tell us, you pull into the house, is there a driveway in the house, in front of the house? Answer, yeah. Question, are there any other cars parked in that driveway when you get to the house? Answer, no. Question, all right. Did you see the gray Jeep that you left the studio with at the house? Answer, no. Question, all right. So what do you do when you get out of the vehicle? Answer, what I remember, I just went upstairs and went to sleep. Question, okay, and you said upstairs. So the house is how many stories? Answer, a couple. Question, okay, so you went upstairs to where specifically to sleep? Answer, to Judy's room. Question, all right. Was Judy in his room? Answer, no. Question, do you recall where Melly's room was in the house? Answer, not upstairs. Question, okay, do you recall where it was if it was not upstairs? Answer, I think it was like front first room when you come in the house. Question, was Melly at the house when you got there, from what you can recall? Answer, no. Question, did you see Melly at any time in the house? Answer, no. Question, all right, so you go upstairs in Judy's room, and what do you do? Answer, crash. Question, crash meaning, answer, go to sleep. Question, okay, at some point do you wake up? Answer, yeah. Question, and why? Answer, phone calls, phone calls, phone calls, phone calls. Question, okay, safe to say your phone was getting a lot of phone calls blowing up? Answer, yeah. Question, and at some point you answered the phone, correct? Answer, yeah. Question, okay, what do you do in response to the phone calls? Answer, I answered it when it kept ringing, and yeah. Question, and so what do you do in response to getting that phone call? Answer, I ended up at the hospital. Question, all right, do you recall which hospital that was? Answer, no, I don't. Question, do you recall what city you were in at this point? Answer, I was in Broward. Question, what city, not the county? Answer, Miramar. Question, do you know if you went to Miramar Hospital? Answer, I don't know what hospital it was. Question, so you get to the hospital, what do you find out when you get to the hospital? Answer, that Anthony and Christopher were deceased. Question, okay, and obviously at that, let me not say obviously, but at that point in time, what do you do or how do you react to that news? Answer, grieving. Question, okay, do you stay at the hospital? Answer, not long. Question, where do you go after the hospital? Answer, I ended up somewhere, somebody's house. Question, all right, do you recall whose house that was? Answer, I don't know whose house it was, but I ended up there. Question, let's start about with the city. Do you recall what city the house was in? Answer, Miramar. Question, do you recall if it was in the same or different area than where Melly's house was? Answer, it looked similar. Question, and just to clarify, was it the same or different house than Melly's house? Answer, different. Question, where did you go when you went to that house? Answer, what do you mean? Question, like where in the house did you go? So you go to the house, where do you go? Answer, nowhere. Inside the house, I was in the back. Question, and would your statement refresh your recollection as to whose house you were at? Answer, maybe. Ms. Smith, Your Honor, please permission to approach. I'm sorry, Ms. Smith, Your Honor, permission to approach. I'm going to show defense counsel the same statement, page 4. Question by Ms. Smith. Same procedure, Mr. Glass, if you could just review page 4. Answer, I don't see nothing about a house here. Question, if you could just read the entire page and when you're done, let me know. Have you finished reading that page? Answer, yes. Has your memory been refreshed as to whose house you were at? Answer, I still don't see nothing about a house here. Okay, I'm going to now show you what's in evidence at State 62. Do you recognize individuals in State 62? Answer, yeah, I do. Question, okay, who are those individuals? Answer, Melly and another dude, Frito. Question, you said Melly and another dude, Frito? Yeah. Do you know Frito's name or any other nicknames? Answer, that's all I know, Frito. Question, Frito. Do you recall ever going to Frito's house? Answer, just that time. Question, just that time being what time? Answer, after I left the hospital. Question, and for the record, what is Frito wearing in the photograph? Answer, a shirt, a white shirt. Question, okay, so after the hospital, you went to Frito's house? Answer, to the best of my knowledge. Question, and what were you doing at the house? Answer, still grieving. Question, who took you to the hospital? Answer, the cameraman. Question, do you recall his name? Answer, Drew. Question, and do you recall who took you from the hospital to Frida's house? Answer, same person. Question, and before you left the hospital, or actually, who went to the hospital with you and Drew? Answer, just Drew. Question, who was at the house, Melly's house, before you left for the hospital? Answer, same people that was there when we got there. Question, okay, same people being the 4 people that entered the Mitsubishi? Answer, yes. Question, so you're at Frida's house. You mentioned, and I forgot exactly where you were in the house. Did you say where you were? Answer, Judy's room. Question, no, not Melly's house, Frida's house. Where were you at Frida's house? Answer, outside. Question, okay, and who was at Frida's house when you first got there? Answer, everybody that was in the house. Question, because I don't know who everybody was or is, can you please specify? Answer, Kobe, Melly, more people I don't know. Question, okay. Was that the first time you saw Melly after you guys left the studio? Answer, yeah. Question, was Melly wearing the same clothes or different clothes than when you saw him at the studio? Answer, nah, he wasn't. Question, nah, he wasn't. You gotta specify. Answer, he wasn't wearing the same clothes. Answer, okay. Do you recall what he was wearing? Answer, just had on some shorts. Question, and how long do you stay at Frida Wang's house? Answer, I don't know. Question, okay. Minutes, hours, days? Answer, could be minutes, could be hours. Question, so not days. Answer, not even a day. Question, so when you got to Frida's house, was it light or dark outside? Answer, light. Question, and you previously said yourself and Melly and someone else was at Frida's house. Was Frida there as well? Answer, I think I did see him, I don't remember. Question, okay, what happens while you're there? Like, you're there, you're outside, what happens? Answer, I'm grieving. Question, and you're grieving. Are you grieving alone? Answer, yes. Are you at the house at any point in time? Do more people come to the house or do people leave the house? Answer, if they did come, I don't know. I was in the back there grieving. Question, at any point in time, did Melly leave Frida's house? Answer, it came to a point where I was there by myself. Question, all right, so you were there by yourself. So the people that you previously said were there were no longer there, correct? Answer, correct. Question, and so do you know where they went during that time? Answer, I don't. Question, and we're still talking about October 26th of 2018, correct? Answer, yes. Question, and this would be shortly after the hospital? Answer, yes. Question, at some point does Melly come back to Frida's house? Answer, around that time I'm still grieving, getting a little, I don't know, yeah, I guess. Question, I guess Melly comes back? Answer, yes, I guess they did come back. I don't know, I'm not sure. Question, at some point does Melly leave again a second time? Answer, I don't remember anything from after that. For me grieving, that was the last thing I remember, was me grieving, and I end up in Gifford. Question, so before you end up in Griffin, sick, if I were to show you your statement, would that refresh your recollection as to Melly leaving and coming back a second time? Answer, I suppose so. Ms. Smith, permission to show him statement again? The court, yes, counsel. Question by Ms. Smith. Mr. Glass, I'm going to give you page 5 and page 6. If you could take a look, you can start in the middle and review those pages and look up when you're done. Are you done? Answer, uh-huh. Is that a yes? Answer, yes. Question, Did that refresh your recollection? Answer, somewhat. Question, okay, so tell us what you somewhat remember. Answer, I just did. Question, if you recall, you said you weren't sure, you went to Gifford. And then I asked you if your statement would refresh your recollection. Does your statement refresh your recollection as to whether Melly left again? Answer, I'm not sure, I was grieving. I'm not sure what nobody did, I was grieving. Question, let's see. I pointed out to you someone was, the person that was wearing the jacket that you identified as Melly was carrying something across his side.
Without the ones like you working tirelessly to keep things running, everything would suddenly stop. No matter your industry, Grainger's here for you with professional-grade supplies. Call, click Grainger.com, or just stop by. Grainger, for the ones who get it done.
Did you see that question? Did you see that satchel again after you left the studio? Answer, no. Question, do you know what was in the satchel? Answer, I don't. Question, okay. Do you recall seeing anyone else with the satchel that night at the studio? Answer, that was 5 years ago. I don't recall. Question, is there anything that can refresh your recollection as to whether or not anybody else was wearing a satchel? Answer, I suppose so. Question, if I were to show you that video again, would that refresh your recollection? Answer, I suppose so. Publishing State 7. Question by Ms. Smith. I'm going to start publishing State 7 at 2:19:01. I'm going to pause at 2:19:13. Does the video refresh your recollection as to anyone else that was carrying the satchel? Answer, yes. Question, who, if anyone, was carrying a satchel? Answer, I see Chris with one. Question, and that's Christopher Thomas? Answer, yes. Question, did you ever have any business relationship with the person referred to as Track? Answer, no. Question, okay, do you know who Track is? Answer, not really. Question, not really, or answer, I don't know who he is at all. Question, do you know of him? Answer, yeah. Question, did you see Track on October 26, 2018 at any point? Answer, no. Question, do you recall giving a statement, specifically the statement that you previously provided, that I previously provided you with here today to the detective in this case? Answer, Question, you have to answer out loud. Answer, yes. Question, that was a statement that you gave to Detective Moretti and another detective, I believe from Indian River, is that correct? Answer, it could be. Question, would showing you that statement refresh your recollection as to anything regarding your interactions with Track on October 26, 2018? Answer, I don't know. I don't know Track. Question, no. My question was, would showing you the statement refresh your recollection as to any time you saw Track on October 26th of 2018? Answer, no. Question, one moment. You said you ended up back in Gifford at some point in time on October 26th of 2018. Answer, yes. Question, and do you recall where Melly was at the time you went to Gifford? Answer, I don't remember. Question, at some point at Frito's house, do you guys all leave, meaning you yourself, everybody that you previously identified that was there? Answer, I don't recall. Question, you don't recall leaving? Answer, I don't recall leaving with anyone. I don't know where I left. I don't know how I left. Question, okay, just to clarify my question, so you mentioned you left. When you left with Gifford, was anyone else at Frito's house? Answer, I don't know. Question, do you recall Melly making any statements in your presence while you were at Frito's house? Answer, I don't recall. Question, would showing you your statement refresh your recollection as to anything Melly told you while you were there? Answer, I don't recall. Question, so you remember them leaving the house at least once, correct? Answer, yeah. Yes. Answer, yes. Question, all right. Now, when they came back, do you recall any conversations that Melly had in your presence that first time after the first time? Answer, I don't recall. Question, would showing you your statement refresh your recollection as to those statements? Answer, no, it wouldn't. Question, all right. Do you have a Facebook page back in October 26th of 2018? Answer, I believe so. Ms. Smith, I'm approaching counsel with what's been marked as state's quadruple I, which was previously shown permission to approach the witness. The court, you may. Question by Ms. Smith. Mr. Glass, do you recognize these two pages that I'm showing to you? Answer, I guess so. Question, and this is a Facebook. Do these statements reflect a Facebook conversation? Answer, they do. Question, is this a fair and accurate representation of the conversation that you had on Facebook? Answer, it is. The clerk states quadruple I will be marked as states 83. Ms. Smith, permission to publish? The court, you may. Question by Ms. Smith. Mr. Glass, can you see that document in front of you? Answer, yes. Question, all right, where it says author, can you read that for the members of the jury? Answer, you want me to read it?
Excuse me one second. Danielle and I received a message that one of your members needs a restroom break, so we'll take a short recess. Do not discuss the case. Don't form any opinion about the case. Don't allow anyone to discuss the case in the presence. We'll be back in finish reading shortly, as soon as we're done with the restroom break, all right? Thank you. Thank you. Let the record reflect the jury stepped out. Mr. Devens, you need a restroom break?
Yes, sir.
Will you raise that to Mr. Devens?
Yes, sir.
Thank you. We're in recess. Local forecast.
Answer, yes. Question, is this the guard gate you testified to at Melly's house? Answer, yes. Question, do you see that screenshot at timestamp 3:51:31? Answer, Question, is that a yes? Answer, yes. Question, do you see yourself inside that red Mitsubishi vehicle? Answer, yes. Question, and were you located? Answer, and where are you located? Answer, passenger. Question, do you recall going through the gate, going through the procedure of going through the gate? Answer, yes. Question, so you get through the gate, where do you go next? Answer, to the house. Question, all right, and can you tell us, you pull into the house, is there a driveway in the house, in front of the house? Answer, yeah. Question, are there any other cars parked in that driveway when you get to the house? Answer, no. Question, all right, did you see the gray Jeep that you left the studio with at the house? Answer, no. Question, all right, so what do you do when you get out of the vehicle? Answer, what I remember, I just went upstairs and went to sleep. Question, okay, and you said upstairs, so the house is how many stories? Answer, a couple. Question, okay, so you went upstairs to where specifically to sleep? Answer, to Judy's room.
Don't keep yourself in the dark like this guy. Lumen. Brilliant men's skincare solutions. In the dark.
House. Answer, not upstairs. Question, okay, do you recall where it was if it was not upstairs? Answer, I think it was like front first room when you come in the house. Question, was Melly at the house when you got there from what you can recall? Answer, no. Question, did you see Melly at any time in the house? Answer, no. Question, all right, so you go upstairs in Judy's room, and what do you do? Answer, crash. Question, crash meaning, answer, go to sleep. Question, okay, at some point do you wake up? Answer, yeah. Question, and why? Answer, phone calls, phone calls, phone calls, phone calls. Question, okay, safe to say your phone was getting a lot of phone calls blowing up? Answer, yeah. Question, and at some point you answered the phone, correct? Answer, yeah. Question, okay, what do you do in response to the phone calls? Answer, I answered it when it kept ringing, and yeah. Question, and so what do you do in response to getting that phone call? Answer, I ended up at the hospital. Question, all right, do you recall which hospital that was? Answer, no, I don't. Question, do you recall what city you were in at this point? Answer, I was in Broward. Question, what city, not the county? Answer, Miramar. Question, do you know if you went to Miramar Hospital? Answer, I don't know what hospital it was. Question, so you get to the hospital, what do you find out when you get to the hospital? Answer, that Anthony Christopher were deceased. Question, okay, and obviously at that, let me not say obviously, but at that point in time, what do you do or how do you react to that news? Answer, grieving. Question, okay, do you stay at the hospital? Answer, not long. Question, where do you go after the hospital? Answer, I ended up somewhere, somebody's house. Question, all right, do you recall whose house that was? Answer, I don't know whose house it was, but I ended up there. Question, let's start about with the city. Do you recall what city that house was in? Answer, Miramar. Question, do you recall if it was in the same or different area than where Melly's house was? Answer, it looks similar. Question, and just to clarify, was it the same or different house than Melly's house? Answer, different. Question, where did you go when you went to that house? Answer, what do you mean? Question, like where in the house did you go? So you go to the house, where do you go? Answer, nowhere. Inside the house, I was in the back. Question, and would your statement refresh your recollection as to whose house you were at? Answer, maybe. Ms. Smith, Your Honor, please permission to approach. I'm sorry, Ms. Smith, Your Honor, permission to approach. I'm going to show defense counsel the same statement, page 4. Question by Ms. Smith. Same procedure, Mr. Glass, if you could just review page 4. Answer, I don't see nothing about a house here. Question, if you could just read the entire page and when you're done, let me know. Have you finished reading that page? Answer, yes. Has your memory been refreshed as to whose house you were at? Answer, I still don't see nothing about a house here. Okay, I'm going to now show you what's in evidence at State 62. Do you recognize individuals in State 62? Answer, yeah, I do. Question, okay, who are those individuals? Answer, Melly and another dude, Frito. Question, you said Melly and another dude, Frito? Yeah. Do you know Frito's name or any other nicknames? Answer, that's all I know, Frito. Question, Frito. Do you recall ever going to Frito's house? Answer, just that time. Question, just that time being what time? Answer, after I left the hospital. Question, and for the record, what is Frito wearing in the photograph? Answer, a shirt, a white shirt. Question, okay, so after the hospital, you went to Frito's house? Answer, to the best of my knowledge. Question, and what were you doing at the house? Answer, still grieving. Question, who took you to the hospital? Answer, the cameraman. Question, do you recall his name? Answer, Drew. Question, and do you recall who took you from the hospital to Frida's house? Answer, same person.
Thank you. Please be seated. Let the record reflect the clearness of the defendant, the counsel, the assistant state attorney, and the ladies and gentlemen of the jury. When we vote, I think we will vote on the readback of Mr. Glass. Madam Court Reporter, could you continue with the readback, please?
Question by Ms. Smith. If you can read that, what does it say next to author? Answer, Fargo. Question, what does it say before Fargo? Answer, Fetty Fargo. Question, do you see where it says Fetty Fargo? Answer, I see it. Question, okay. And who's Fetty Fargo? Answer, it was me. Question, who was that? So was that your was that how you identified yourself on Facebook? Answer, kinda, sorta. Question, who were you having these conversations with? Answer, right now it looks like I'm talking to myself, like I was texting. I don't know who I sent it to. Question, do you see where it says participants? Answer, okay, so texting Melly. Question, that was page 1. I'm going to now publish to page 2. I'll publish it in part since it's a little small. Can you see that in front of you? Answer, yes. Question, I'm going to scroll up. What was the purpose of you having this conversation with Melly? Janelle Demons. Answer, I don't know. Just everything was questioned. Question, when you got to Gifford, were you looking for answers? Answer, not just me. Question, were people kind of pressing you for answers? Answer, correct. Question, and did they have any impact whether or not you reached out to Melly? Answer, I don't know what you mean by that. Question, so again, you said that people were looking for answers. So did you reach out to Melly looking for answers? Answer, I did. Question, is that the gist of that conversation on Facebook? Answer, is that just? Question, meaning the gist of the conversation, was that the purpose behind the conversation and the general conversation that you had with him? Answer, yes. Question, do you know who Jamie King is? Answer, I don't know who she is. I know of her. Question, do you know her relationship? Answer, his mom. Question, do you know the relationship between Jamie King and Anthony Williams? Answer, I don't. Question, if I were to show you a copy of your statement, would that refresh your recollection? Answer, nope. Question. Sorry, Ms. Smith, and 1 moment to confer. Nothing further at this time. The court, counsel, thank you. Any cross-examination of this witness? Mr. Howard, yes, sir. Good morning, ladies and gentlemen. The jurors, good morning. Cross-examination by Mr. Howard. Question. Good morning, Mr. Glass. Mr. Howard, Your Honor, do you mind if we could move the monitor from in front of the witness's face? The witness, I do, I mind. Mr. Howard, okay. Would you mind, Your Honor? The court, I don't mind. Is there a specific issue that you have, Mr. Glass? The witness, I do. Ms. Smith, Judge, can we approach sidebar? Mr. This is direct continued cross-examination by Mr. Howard. Good morning, Mr. Glass. Good morning, sir. Answer. No verbal response. Question. There was no response to this. Answer. No. Question. To your text on the first page. Answer. No. Question. On the second page, the state was discussing that essentially you were inquiring of Mr. MELLY what had gone on because you were trying to get information. Answer. Yeah. Question. And you see a conversation here where you get a response. I want to direct your attention to. Answer. I see it. Question. That statement. It says, I showed them niggas more love than they parents. Right? Do you see that? Answer. I do see it, bro. Question. Thank you. And the next statement by the next message in sequence is again from MELLY. It says, TF. What does that mean? Answer. You tell me. Question. Okay. What does that mean? Answer. I don't know. Question. Okay. So you were having a conversation and you didn't understand the response? Answer. I don't know what TF means. Question. So you didn't understand that response, correct? Answer. I just said it. Question. Okay. Then there's another one that says, men, tell them fuck that if they think I did some shit like that. We can go to war. Nigga, you know I would never do nothing like that. Do you see that? Answer. Yes, I see it. Question. Okay, so state had mentioned that you got arrested recently and charged criminally, correct? Answer. Correct. Question. And on May 30th, not too long ago of this year. Answer. Yeah. Question. And one of the charges that was made against you was obstruction of the service of the execution of a search warrant. You're aware of that. Answer. I am now. Question. Pardon me? Answer. I am now. Question. So you got charged and you have no idea what you were charged with? Answer. Correct. And you are now on pretrial release? Answer. I bonded out, sir. Question. Okay. And while you're out on bond, you are of the opinion that if you don't come here, answer, I'll be in jail. That's the only reason. The court, excuse me, what happens is when they make objections, you wait before you answer. Objection overruled. The witness. Got you. Got you. Hold on just 1 second. I'm going to reread that portion. Okay, and while you were out on bond, you are of the opinion that if you don't come here, I'll be in jail. Ms. Smith, objection, Your Honor, relevance. The witness, that's the only reason. The court, excuse me. What happens is when they make objections, just wait before you answer. Objection noted, it's overruled, proceed. The witness, got you. By Mr. Howard, question. You're of the impression if you don't come here and sit in the chair and testify, you're going to go to jail. Answer, correct. Question. Okay, there are several instances which Ms. Smith, prosecutor, that questioned you, showed you a statement that you previously gave. Remember that? Answer, yes. And you told us you remember seeing me in the deposition not too long ago. Answer, I said what? Question, you remember seeing me last week on Friday? Answer, yeah, I remember. Question, and you recall at the time that your statement to the detective was a few days after the incident? Answer, you say, do I recall? Question, that's what your recollection was at the time. Answer, yes. Question, a couple of days after. Answer, a couple days after. Question, and now after seeing the statement, you realize that it was 4 months later, right? Answer, you say what? You said what? Question, the statement you gave to police. Answer, you're telling me it was 4 months, or asking me. Question, pardon me? Answer, are you telling me or asking me? Question, I'm asking you. Answer, that don't make sense. If you asking me, I told you it was there. It was 3 to 4 days after they died. Why are you asking me if it was 4 months if I just told you? Question, okay. So in a statement that you gave to police back then, you claimed that you had gone into the red vehicle in the rear seat, right? Answer, that was 5 years ago. To the best of my knowledge, that's what I said. Question, you're saying the statement was a few days after, right? Answer, what did, question, the statement that you gave to the police was a few days after the incident. Answer, yes. Question, and you said then that you had gone into the rear of the red vehicle. Answer, to the best of my knowledge, yes. Question, and then you watched this trial unfold on TV over the last couple of weeks, right? Answer, no. Question, you didn't watch any of this trial? Answer, I watched it, but I didn't watch it unfold or whatever you're trying to say. Question, okay. You watched this on TV, this trial. Answer, on the phone. Question, and you saw a video of yourself get into the red vehicle, right? Answer, correct. Question, and you learned that the statement that you gave a few days ago, a few days after the incident was gone. Well, let me reread that question. And you learned that the statement that you gave a few days after the incident was wrong. Answer, because I said I was in the back and I was in the front. Question, yes, exactly that. Answer, that piece? Question, yes, that piece. Answer, okay, yeah. Question, you forgot where you sat in the vehicle a few days after? You can answer. Answer. Answer what? Question. That question. Is that correct, sir? Answer. Did I forget? Question. Did you forget? Answer. I could have made a mistake and said I was in the back and remembered that I was in the front. Question. So when you told the law enforcement officers that you had gone into the back of the vehicle a few days after the incident? Answer. That's what I thought to the best of my knowledge. Question. That's what you thought? Okay. And when you got to Melly's house that morning, you had a key? Answer. Did you have a key? Question. No, I didn't. Did you? Answer. No, I didn't. Question. Who had a key? Answer. I don't know. Question. Do you know of anybody having a key to Melly's house? Answer. I don't know. Question. Okay. But you did gain entrance to the house that morning after you left the studio. Answer, yeah. Question, and then you said you just went and crashed and went to sleep in Judy's room, right? Answer, factual. And you were awakened by your friend Drew? Answer, I did not say that. Question, were you awakened by your friend Drew? Answer, I said I was awakened by phone calls. Question, did you ever make a statement differently where you claimed that you were awakened by Drew? Do you understand the question, sir? Answer, I don't even remember getting asked a question. The court, all right, restate your question. Question, did you ever make a statement to the police? Answer, I don't recall. Question, okay, do you recall now being asked this question and giving this answer? Question by the detective. Then, and so when you first saw Drew, when did you see him? Where did you see him at? Your house or Frida's house? Answer, at the house in Miramar, at Melly's house, okay? He woke me up. It was like, come to the hospital. You said that? Answer, I don't recall. Question, don't recall? All right. When we spoke to you last week, you said you were awakened by phone calls from Christopher Thomas's mom, right? Answer, plenty of phone calls, different people. Question, pardon me? Answer, different people. Question, different people. And the one that you answered was Ricky. So you were awakened by a phone call from Ricky. Answer, to the best of my knowledge.
Think you know Harbor Freight? Think again. Come see for yourself at a store near you.
Up with phone calls and not Drew that woke you up in person. Answer, correct. Question, okay. So you smoke a lot of marijuana, right? Answer, possibly. Question, you smoke it anytime You get a chance, I think is how you phrased it. Answer, it's your answer, yeah. Question, that was your answer. Answer, I smoke when I smoke. Question, you smoke when you smoke? Answer, yeah. Question, and when's that? Answer, when I smoke. Question, and when would that be? Answer, when I smoke. Question, how many times a day? Answer, twice, 3 times maybe. Question, and on the night in question, before you got to the studio, on the day in question, you had smoked at least 2 joints, right? Answer, that's your guess. Question, that's what you said, right? Answer, I don't recall. Question, okay, and when you got to the studio, you were smoking, correct? Answer, possibly. Question, were you or weren't you? Answer, that was 5 years ago. Question, you forgot? Answer, I don't recall. Question, and you were drinking Hennessy, I believe, or do you not recall that either? Answer, it's possible. Question, possible, but you don't recall. Answer, I don't. Question, okay, so you don't recall much from that night then, do you? Right? Fair? Answer, right. Question, and when you got in the red vehicle and left, you went to sleep in the vehicle when you left the studio, right? Answer, yeah. Question, and you didn't wake up until you got to the guard gate? Answer, I woke up when we came to a stop. Question, you did not wake up until you got to the guard gate. Am I right or wrong? Answer, I woke up when we came to a stop. It was at the guard gate, yes. Question, have you ever seen track with a gun? Answer, it's possible. Yes, maybe so. Question, okay, so you don't know of any friction between Melly and Anthony Davis at any time. Anthony Williams at any time. Answer, not that I know of. Question, and you don't know of any friction between Melly and Christopher Thomas at any time. Answer, not that I know of. Question, you didn't see any friction at the studio that night of any kind, did you? Answer, I didn't. Question, you did? Answer, I didn't. Question, with respect to your daily marijuana regimen, did you smoke before you came here today? Answer, I did not. Okay, I have nothing further, Judge, thank you. The witness, I should have. The court, counsel, is there any redirect, Ms. Smith? Briefly, your Judge. Briefly, Your Honor. Redirect examination by Ms. Smith. Question, Mr. Glass, did you live in Broward County back in October of 2018? Answer, I did not live here. Question, okay, when did you come in relation to this incident in Broward County? Answer, I was picked up probably, I don't know, I was picked up on the weekend or something like that. Question, so how would you, I guess, date how long you were here prior to the incident, time frame? Answer, 3 days, 2 days. Question, okay, so you were not a full-time resident of Melly's residence? Answer, I was not. Ms. Smith, nothing further. This witness excused? Yes, Your Honor. You may step down.
That concludes the readback of Glass's testimony, so you may now retire and continue with your deliberations. Thank you, ladies and gentlemen. Thank you. Let the record reflect the jury stepped out. Counsel Rainwall and defendant. Counsel, I have another question that the jury posed Can I do that just in writing here? Is that all right with everybody?
That's fine.
I'm sorry, Your Honor, I think you should say you must rely on the testimony.
That's what I started to write.
I'm sorry.
No, you're right.
I'm sorry, what did you just say? Can I get that typed up, please?
More than once I'll say it. You must rely upon the testimony. Anything else you want to say to me? State, all right?
That's fine, right?
There are foods here, so we're gonna utilize this time for lunch. You hear that?
Lunch?
Lunch.
When should we be back?
You tell me, I mean, where you going? You buying?
Yes.
The 30-minute window thing is out the window.
No, I mean, 30 minutes, that's fine. Just be available.
Yes, sir. You have our numbers.
All right, is that good with you, Madam State?
That's right.
All right, so we need to avoid it. All right, thank you.
Thank you, sir.
We're in recess.
The readback of Travion Glass's testimony is now complete, so the jury has heard it all. We are going to start taking your questions now, so keep them coming to us on YouTube, Twitter, Facebook, Instagram, Twitch, TikTok, and Threads, and we'll get to as many of them as we can. Michael Bryant, host here at Law and Crime, and also an attorney, is here with me. Offie Patterson is an attorney here with me as well, and Mina Lona, a SiriusXM host, is here. Thanks everybody for being with us today. So let's get to our first question. Smurf Duh Gemini from Twitter, Michael, why did the phone say mobile the whole time, and we know that we had to stop at red lights?
Why did the phone say, oh, as if it was moving? Is that their question?
Yeah, Melly's phone said mobile the
Yeah,
entire time they were driving, and then it says outside stationary when you exit the vehicle, according to the prosecution.
Yeah, I'm guessing that the technology, as you know, I'm not a big fan of it, but I'm guessing that it requires a certain period of time actually motionless before it registers as something other than mobile. That'd be my best guess.
All right, let's get to this next question. This is for you, Offie. This is from @JustChillin' here, and we've heard from @JustChillin' here quite a few times from Twitter. Do the defense attorneys in this panel think that the defense picked a good strategy with taking Melly out of the crime scene, or do they think there could have been a better strategy?
So I think they had to choose. So I think they wanted to rely on their alibi witness. And their alibi witness said he wasn't there. They said he was at the house at the time of the murder. And I also think that they didn't have to get a crime scene reconstruction expert, and it saves them having to just add explanations because we knew Melly was likely not going to testify. And putting him there would have required a lot of explaining and a lot of testimony. And you wouldn't want to open Melly up to too many questions if he was going to testify. But I think it wasn't necessarily the best strategy at the end of the day, because the 9807 number, I do believe, was sufficiently tied to Melly. We believe it was his. And I think that if you follow the phone, you follow and you find out and you learn how the murder took place. So I don't know if it's going to work out, but they use that strategy because of their alibi witness.
Mina, I'll send this next question to you, and it's about Travion Glass. The testimony we just heard read back by the clerk for the jury, and he was with everybody at the recording studio that night. So Cindy Hedden asks from Twitter, I just answered part of the question for you, Mina, but who is Travion Glass? I haven't been able to watch much of this trial.
Travion Glass is a childhood friend of Juvie. They've known each other for over a decade. He was in that red Mitsubishi, which is the other car that was leaving the studio the night in question. He was staying at the house as well, Melly's house. So he has a lot of ties to not only the people who have passed away, but also Melly and this YNW collective. So he was one of two people that were actually in the red car that testified and gave their account. So basically friends of the people who were affected, and they were there so they can give us their opinion on or their recollection of what they remember seeing.
Michael, this next question is from you. It comes from @Reba05 from Twitter. As legal experts, do the questions asked by the jury lead you to determine which way the jury is leaning?
You know, it's always tempting to put probably more into the questions than is the reality. But of course, you want to use that as any sort of insight as to which way they're going. Hopefully, you interpret it as something that helps your side, but that isn't always the case, and sometimes it's totally irrelevant. In this case today, we already know they wanted to get a statement made by Bortland Henry at the hospital, and then they changed their mind and said, no, we don't want that. So what does that tell you? Does that tell you that they've decided amongst themselves that the statement means nothing? And we believe it's the statement in which he first said, hey, this all happened as a result of a drive-by. Does it mean that they believed his statement, don't need to hear it again, or they don't believe it and they don't need to hear it again? So the short answer is you just never know, but you try to interpret it as best you can for your side.
Alrighty. Well, we're going to sign Offie off. So, Offie, thanks for being with us today. We really appreciate it. And we're going to take a quick break. When we come back, we are going to have Terry Austin come on and tell us what happened in that courtroom and take more of your questions. So stay with us. I'm Anjanette Levy. You're watching Law and Crime. We'll be right back.
because a lot of folks evaded their efforts, however those efforts might have been. So that's why we only heard from 2, and there could have been probably 3 or 4 others that were there that night. Police were not successful in corralling them or encouraging them to testify.
We do know that Jacoby Mills and Dontavius Withers, who were the other 2 people in that vehicle, I just want to add to this, were interviewed by law enforcement. Dontavius Withers, for his part, gave a couple of different stories about whether or not Melly was in the vehicle or not. So he certainly gave inconsistent statements on that point. Jacoby Mills was interviewed at one point in time, gave a statement to law enforcement. So why he testified or didn't, we don't know, but he said some things that were pretty incriminating to Melly. So there you have it. Our next question comes from Trez Anthony. I have a question. Did Glass also testify, Mina, and say that Melly had on shorts after the studio session?
He did. And that was that bombshell. It was the headline everywhere. All the hip hop blogs. Melly had a change of clothes. It was a big revelation, and he did testify. And now it really just comes down to, can you piece everything together? I think I heard Linda say this. You know, if Melly was home, just throwing it out there, because that's what Adrian Davis said, he might have changed into shorts.
Swagster
I love that.
from Instagram. It asks, is it common, Terry Austin, to get a guilty verdict without the murder weapon?
I would say it's fairly common. I think most people believe you have to have that quote-unquote smoking gun. And in a circumstantial case, I think most people think it's very hard to find someone guilty. But jurors, they are very smart. They piece together, they use their logic, and they figure out what actually happened if you have enough corroborating evidence. So the point being, if you have those shell casings, if you have the trajectories, if you have all of the information from the phones, putting everyone in the same place at the same time, if you have cameras where you can piece it together, if you don't have a gun and you have all of that other information in a case like that, I do think the jury could come to a conclusion that there is a guilty verdict. But we'll have to see if there's enough evidence here for the jury to come to that sort of conclusion. What I will say, it is much more difficult when you don't have that weapon. So it's going to be hard for this jury.
We shall see. These knee, I think I got that right on Instagram, Michael Bryant. Can he be found guilty of killing one of them but not the other one? Or if he gets found guilty, will he be responsible for both?
Yeah, it's very interesting, and it crosses over into the felony murder issue that we've talked about early on, and where the judge decided that was inappropriate because we couldn't determine which person died first. Bizarre analysis, in my opinion. But having said that, in theory, yeah, he could be found guilty of one without the other, but that defies logic. I mean, how would that exactly happen? I mean, talk about holes in the fact pattern. Now we got tons of them, because there's just no suggestion that there was a second shooter, or that somehow the drive-by maybe killed one and not the other. But technically, yeah, they could find he is responsible for one of the deaths and not the other. That would be bizarre.
Let's get to some TikTok questions now. This one's for you, Mina, and I hope that you've done your studying on the cell phone data. So if not, that's fine too. But that was a lot of information to process. It comes from Trey Joseph 23 from TikTok. Couldn't the phone have been given back to Melly when Bortland met back with them at Fredo's?
I mean, anything could have happened. We just don't know what happened. You know, the phone is a big contention here. Who had the phone? Where was the phone? Was it outside? Was it in Melly's house? Was it at Fredo Bang's house? I think that's the problem with this case. We don't know for sure, and everyone has a different interpretation of the phone evidence that is there. But I do think the prosecution did a good job of making sure that we know that the phones are tracking all together. And then also, outlining when the phones actually split apart from car to car. Did I get an A? Was that good?
I think you got an A. I think we need to keep in mind too, there was the text with the pin to Fredo. So if you're sending a pin to Fredo and Fredo's coming to pick you up on Miramar Parkway, then how on earth, you know, that's a lot to think about. How on earth are you sending a pin and then not having your phone and then finding it back at Fredo's after Cortland gets there, and then Cortland had already had all of his stuff taken at the hospital. They took his clothing and everything, and they seized the Jeep. So,
well, I think the timing is also really important because Cortland got to the hospital at I believe 4:35, and I think the pin came down, and correct me if I'm wrong, at 4:42. So to answer the question, you can't be two places at once. So by the time the pin was sent, Cortland was already in the hospital.
Hey, and Jeanette, I have a question.
I think you.
I have a question.
Yes.
How
of course,
far
Michael.
are we really in the not too distant future from saying, you know, there were texts, there were phone calls, somebody dropping a pin. It was AI. You know, there were no texts by any people. There were no phone calls by any people. There were no pins dropped. AI did it. That's who you're looking for, AI. I don't think it's really that far off before we're going to hear those kind of weird arguments.
I mean, I think you're probably right about that. AI terrifies me a little bit, especially when I hear about all these warnings from scientists who've been working with it. Yikes. So you may start hearing that sometime in the future. Who knows? Let's take a quick break. When we get back, we'll take more of your questions. Keep them coming in. I'm Anjanette Levy, and you're watching Law and Crime. Stay with us.
Are you suffering from sinusitis?
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 30 March.
Welcome back. I'm Anjanette Levy. We're taking your questions in the YNW Melly double murder trial. We are in verdict watch. The jury is deliberating after hearing a readback of the testimony of Travion Glass, one of the witnesses for the state in this case, who was at the recording studio that night. So we're in verdict watch. Keep it tuned right here because we are going to have that verdict for you when it comes in. For Terry, I'm going to send this question over to you. It's from TikTok and it's from Reba9488. Is there cell data showing the phone location where the "I did that" text was sent?
Well, no, because the "I did that" text was sent after the shooting occurred, and it was messaging back and forth between someone and Melly where he said, you know, "I did that." I think it was Gibbons who was the other individual who sent that message to him. And the message was, "How are you? Are you okay?" And this was after the shooting. And then theoretically we see Melly saying, you know, "I did that, shh." But I don't see those messages as matching up. I don't see one as a response to the other. It seems a little bit out of context. The prosecution believes that that is an admission, but the messaging was not related at all to the actual shooting, and it wasn't tracked as far as where the cell phone was at the time that that message occurred.
The next one is Big Pook _ from Instagram. What do you think the jury is thinking, being that they asked for that testimony, Michael Bryant? This is again about the Travion Glass testimony.
Yeah, I really just think it all gets down to the alibi, and I really am curious if they ask for Mr. Davis' testimony. That'll solidify that in my mind, that they are really focusing on whether or not Melly got out of that car, whether or not he was just at home when the phone rang and they learned about their friends' deaths. To me, that's it. That's the second part of that puzzle. So to ask for his testimony in and of itself, yeah, maybe they were just curious about the change of clothes, because remember, he said, "I don't know," and I don't recall more than he said anything else, and whatever you show me ain't gonna help. So if it was just his testimony, then it was probably about the clothing change.
Mm-hmm. Let's get to the next question. Mac2K from YouTube, Mina asks, if Melly gets found guilty, will the alibi witness, Adrian Davis, be charged with anything for basically lying on the stand?
So I'm not an attorney, but I know enough to know that if they wanted to, they could, but the likeliness, I don't think it's going to be likely. But if the attorney, if you guys want to correct me, but from what I've seen before, they can if they can prove it. But I think what they're trying to do here are get the murderers, right? And not so much the liars.
Yeah, and you did a great job answering that question because they really don't do perjury very often. So good job with that one. Mrs. Navalta from YouTube, do you think that since the jury asked for the testimony of Mr. Glass and Mr. Kelly, that the jury could be leaning more toward a guilty verdict? Terry, do you have any feeling on that?
Well, yes, at first I did think that, because if you think about the testimony of both of those witnesses, one, Travion Glass, he said Melly changed clothes and he did not see Melly get into another car, so that does favor the prosecution. And for Kelly, for Michael Kelly, he was the crime scene investigator. He basically talked about the trajectory of the bullets, and he was actually not on the stand that long, but the jury, I think, wanted to reiterate what he said and see exactly what it was that he said. And so both those things do sort of favor the prosecution. But when we heard the testimony of Travion Glass, one of the things that went through my mind was they're probably trying to determine his credibility. And like Michael said, most of the time he said, "I don't know, I don't remember," or "nothing is going to refresh my recollection." The only piece of information that he really did say, in my mind, is that clothing. I don't think he really seemed as though he knew what was going on after, the shooting and whether or not Melly came back to Melly's house. He knew Melly came back to to Frito Bang's house, but it didn't seem clear to me when they read back whether he went to his own house. So I think all in all, it's probably a wash. We'll see if they ask any more questions about testimony. And again, I agree with Michael. If they ask about Adrian Davis, then that is telling you that they're trying to figure out who's telling the truth, and they see that as two pieces of very crucial information.
Michael, really briefly, we have to hit this break here in about 30 seconds. Ebony Palmer from YouTube asked if Melly was found guilty, does he still have a chance for an appeal, even though earlier the judge asked him if he was satisfied with his lawyer's performance, and he said yes.
Yeah, he'll have lots of appellate rights. And even the ineffective assistance of counsel, which is what that judge note alludes to, you could still make that argument, even though it was a weird thing to ask in open court there, I have to say. Won't affect him, though. He'll have plenty of opportunities.
Things always come up on appeal. You know, they get new information or what have you. The appellate lawyers, if they are different, will find other information maybe that the defense attorneys at trial ignored. So you just never know. All right, guys, we're going to take your questions after the break for a little bit here. So stay with us. I'm Anjanette Levy. You're watching Law and Crime. We'll be right back after this break. Welcome back and welcome to Law and Crime here on this Friday afternoon. We are on verdict watch in the trial of YNW Melly, whose legal name is Jamel Demons. The jury is deliberating and they're trying to determine whether or not the state proved its case against Demons for the murders of his two friends, Chris Thomas Jr. and Anthony Williams, back on the early morning hours of October 26th of 2018. If convicted of those first-degree murder counts, YNW Melly faces the possibility of the death penalty under a lower threshold that was signed into law by Governor Ron DeSantis earlier this year. So he really is one of the first people, if not the first, to face the possibility of the death penalty under this new 8-4 threshold. It used to be a unanimous vote necessary to impose the death penalty. There is a co-defendant in this case. His name is Cortland Henry. He goes by YNW Bortland. He will go on trial for the murders of YNW Juvie and YNW Sack Chaser in October of this year. So stay here as we continue to follow the verdict. Also, we're taking your questions for a little longer today in the trial. So keep them coming to us on YouTube, Facebook, Twitter, Instagram, Threads, and TikTok, and we'll get to as many of them as we can. We have so many platforms now, hard to keep track of them all. Our next question for our guests comes from Ty from YouTube. Do you think the jury will have a hard time with the conviction, given the fact that the state never put the gun in Melly's hand? So, Mina, I'll send that over to you.
I think they're doing a good job of building what they think happened, even without the gun. I think that recreation was really critical with that. It kind of depends on what you want to believe, right? Do you want to believe that the medical examiner and the recreation of the crime scene, do you want to believe that? Do you want to believe some of the people that are witnesses, particularly Adrian Davis, who says that Melly wasn't even in the car? I think it just really comes down to what you remember. There's so much information. We're getting text messages and pictures and contradictory witnesses. And it's hard to keep track of, especially as we mentioned with all the names. So I think this really comes down to what do you remember and what makes sense to you? What's plausible, what's not plausible?
Makes sense. I think that's a perfect answer, Mina. Let's get to our next question. Get Black with Me from YouTube. Do you think since there was no weapon found that the jury might pick the manslaughter charge, Terry?
Well, I think there hasn't been a theory put forth for that manslaughter charge. We know that the prosecution asked for the charge. It's a lesser included charge for the murder charge for that first-degree premeditated murder. And I think it was done to sort of have an alternate theory for that jury to consider. But even during the closing argument by Bradley, she basically said there's nothing here to show or to support the manslaughter charge. So I don't think the jury is going to get to that issue. I think it's either going to be that first degree murder, or I don't think they're going to have any theory for that manslaughter. Remember, you don't have to intend to kill someone for manslaughter. You have to have an intentional act that ends up in causing the death of the victim. But what would that intentional act be? Were they playing with the gun and they shouldn't have been pointing it? None of that has been established in the trial, so I don't think they're going to get to that. And I think the absence of a gun in general isn't going to really affect that manslaughter charge at all. And Anjanette, I just got a message that there is another jury question that just came out. They haven't announced it yet, but I just thought I'd let you and the viewers know that.
Oh, thank you for that update, Terry. You're so on top of it down there. I'll be interested to see what that question is. Do you have any feeling or do you see any movement around there letting us know potentially whether or not this question will be read soon? I assume all of the lawyers are just kind of hanging out around there waiting for either a question or a verdict or what have you.
Well, that's right. I mean, initially the judge said 45 minutes, then he changed it to 30 minutes to come back. And I saw the defense team say, look, what's the time frame? Because you said 30, but you were ready before that. So they are hanging by the courtroom very closely, and they are down there now. I don't think they've read it off. I will also say, Anjanette, as we were leaving, there was another jury question that we haven't even talked about besides the testimony readback, and the jury wanted to know the exchange rate for meters to feet, and the attorneys all agreed, and the judge agreed that they should just let their recollection of what that testimony was just serve as the answer to that question. The answer hasn't been given back to them, but they will be told, whatever you remember, that's what we should go with here. They're not reading anything back for that. So this next question could relate to that, or it could be something totally new, but we should see that shortly.
Wow, this takes me back to running track in high school. 1,600 meters was a mile, 4 laps around the track. 400 meters was a quarter mile. We'll see what happens with all of that. Maybe somebody back there ran high school track. Let's get to this next question. This comes from Malcolm Chandler from YouTube. Michael Bryant, 100K track. That's his Melly's manager. His phone and Melly's phones were both together on Pembroke and US 27, the crime scene. Is this why he turned in the phone to avoid accessory after the fact? We had that testimony about him having possession of Melly's phone and later turning it over to law enforcement who had a warrant.
Well, it was a good idea, and what his motivation to do it was, who knows? But yeah, it's certainly an important piece of evidence. Those phones, they've been quite the headache in this case. And so, yeah, I think it's just common sense. Unless he's trying to hide something, why not turn over that phone?
Yeah, most certainly. And they had that warrant. I read some court documents about the whole thing, too. It was pretty wild. Let's get to our next question. Gavin _Davis 43 from Instagram. Actually, I'm going to skip that one for you, Mina. I don't like that one for you. Let's send you something else. From TikTok asks, hi, Law and Crime Network. Do you think that the prosecution is relying on witness statements? How do you view it, Mina? I mean, we heard testimony from many witnesses in this case.
I think they're just throwing it out and see what sticks. They're just basically putting everything out there, and anything that they have. So I don't think they're relying too much on witness statements. I think they have a plethora of evidence, and it's all different. You have medical examiners, you have people talking about cell phone data, you have the recreation of the actual car, and then you have an eyewitness. And then you have the lead detective. So I think they have a variety of different things that they've presented in order to try to, secure their guilty verdict.
Reba05 from Twitter. I think we've heard from Reba before as well. If the jury is asking about non-witnesses, could that result in a mistrial? I think she means, Terry, the fact that they asked about the name mixed up. Probably a mix-up of names, but if the non-witness has a connection to Melly and the person was not mentioned during the trial, then it seems a juror may have been doing the outside research. So could this whole name mix-up thing cause a mistrial?
I don't think it could cause a mistrial here because it seems fairly definitive that the name that they came up with, this Cortland Sutherland, was not a real person. So I don't think anybody was doing any research. No one got some other names from the outside. They came back and said, oh, we meant, Cortland Bortland Henry. So they just basically got the name wrong. And just getting the name wrong isn't a reason for a mistrial. It was clarified. That's the purpose of having these questions. You don't hear everything all the time. Even with 12 people deliberating, not everybody gets everything. So the system allows them to ask questions, and then the judge will talk to the attorneys and they'll figure out what the answer should be. So I don't think in this instance getting that name wrong means anything at all, except somebody didn't hear, or many people didn't hear exactly what it was. So no mistrial for that.
Let's get to another question here. We got a lot of really good ones coming in. Chosen One from YouTube. Why were the messages stating they killed all of them already and the picture was a target over his face never investigated? Could lead to the shooter. So Chosen One, Michael, is asking about messages stating they killed them in the picture with the target over his face. They had talked about.
Counsel, the assistant attorney to the jury is in the jury. Counsel, after we went to lunch, I received one message from the jury signed by the foreperson, and it basically is the boxes checked, requested new evidence, hyphen, rescind previous request. It was on stage jurors who requested to, wanted to hear the testimony of Michael Kelly, have rescinded their request. We apologize for any inconvenience. So they don't need to read back to Mr. Kelly what they're telling us. Second thing is when Gale was in there, I guess trying to get them lunch or something like that, bring them a lunch, he received from not the foreperson, but a short note. It was folded up. That's it. And it was folded up. It was passed to him, and it says, "Are we allowed to have Apple Watches? Someone has one." It's not signed or anything, but that was the message that was passed to me, and that's why when we got the message, I tried to get everybody to come back to just talk about it.
Was that another jury? Overture.
Yes, sir. We're gonna wait for 1 second, so I want Gary in here.
Okay.
And we just want to respond to
the mic over here. Good work. I can't even reach it over there.
defendant, this counsel, the assistant state attorneys. So what I was sharing with you regarding the message that Gary advised me was that yesterday when we started, sent the jury to deliberations, Gary asked for all their electronic devices or phones, including smartwatches and Apple Watches. And in fact, one of the jurors has an Apple Watch and presented it to Gary, which he has it secured with all the other electronic devices. Is that correct, Gary?
Yes, sir.
And secondly, he's also indicated that when he viewed various jurors, he was unable or did not observe anybody wearing a smartwatch. Is that correct?
Correct.
So I don't know how you want me to handle this, and I guess that's one of the things you could talk over for a second amongst yourselves. And I also have a message here from the jury, another message, and it says, "What if we can't come to a decision? Question mark. Everyone is stuck on which side they've chosen." Signed by the foreperson. So,
I think we're prepared to the extent that the court is. I think we're prepared to offer our responses.
That's fine. If you're ready, Ms. Madam, you ready?
Yes, Your Honor.
All right, go ahead.
I know the court's not going to want to hear this, but with respect to the first of the notes.
Excuse me, when we talk about the notes, we're talking about the one.
Okay, the first would be the Apple Watch. Okay.
The individual juror?
Individual juror Apple. As far as that is concerned, my understanding of how Apple Watch works, at least how mine works, is that there has to be some proximity to a phone for it to provide access to the internet. I don't know if I'm wrong.
There are versions that have some link and cellular capabilities
would just be, we would suggest that we identify who it is, we just retrieve it and keep it moving.
So I think on that, the remover pass the note to your deputy, bring that potential particular juror out, and ask who has it, so we actually know.
No, I wouldn't want to isolate them. I'd want to bring up the whole panel and have the court inquire as to whether or not anybody has any remaining electronic devices.
But as part of the court's instructions in 3.13 indicate that if anyone becomes aware of a violation of these rules, which includes not having an electronic device, they must inform the court. I think for record purposes, we need to identify the person who has the Apple Watch and needs to be removed from the room. We don't know whether there have been any other violations, perhaps someone looking up something online, unless we inquire further.
Thank you. You all done anything?
Well, two things, Your Honor. One, the person in passing up that note did abide by the court's instruction that Ms. Smith just referred to, but it doesn't say necessarily bring them out and single them out and expose them as a snitch. and I think we're jumping the gun by suggesting that if we find that somebody had an Apple Watch, they need to be removed from the room. The Apple Watch needs to be removed from the room. Is that what you're saying? Okay, so we concur in that respect as far as this goes.
This is my thought, respectfully. I just bring the jury in as a group, just let them know I have a message. This is, are we allowed to have Apple Watches? Someone has one. I don't know if this, when they're talking about this, one of the jury does have an Apple Watch, but it was taken away, or not taken away, but they presented to Gary when he asked for it the other day before the jury went into deliberations. He goes in and just retrieves all the phones and electronic devices, and they presented to him. So maybe that, and I'll ask again, I'll ask somebody else to watch on them now or anything like that, a smart watch, and just see what the response is. If they say if nobody responds to it, there's no smart watch, then we'll take the next step and we'll see where we go from there. But I'm going to ask the jury as a whole if anybody has a watch.
Your Honor, with respect to that, the only suggestion that I would make would be for the court to inquire if anybody does have an Apple Watch. When they go back to the room, please give it to Gary, as opposed to them feeling castigated in front of the public.
I still need to know, though, if somebody has a watch and they give it to Gary,
who it is.
I need to know, make sure they haven't used it. You know, 'cause he specifically, I instructed him they can't have it back. I don't know that I ever talked about smart watches or Apple Watches per se, but I know in the standard instruction, which I read to them, I told them they can't have electronic devices, phones, cell phones, any electronic device have to be left here in the courtroom. Gary goes in and does it again, and when they go in, make sure he collects everything, so, and he has it stored. So let me just take it one step at a time, and we'll see what they say, and then if we need to inquire further, we'll talk about it.
Okay.
All right? So just ask the jury to come in for a second.
Yes, sir.
Oh, wait a second. I'm sorry. Did I mention this, Steve?
The third?
I got another question.
Your Honor, at that point, I think it's appropriate to read the Allen charge based on that specific comment. I can print copies for the court and counsel.
Well, it says here, what if we can't come to a decision? Doesn't mean they're at an impasse now. Everyone is stuck on which side they've chosen. So if they say they can't reach a decision, that's one thing, but this doesn't really say they can't reach a decision. It says, what if we can't come to a decision?
I think they're saying they have not, and what if meaning what is the procedure that we follow now that we are in that place, as opposed to what if that eventually happens. So we interpret it a little bit differently, Your Honor. As to what we should do about it, I'd like to confer with co-counsel. As to the other note, this is the part that I know the court's not going to like too much. We have made taken a position that the statements that were requested at the same time and should be read back at the same time. Now we've received a situation, or now we've come to a situation where testimony that by a state witness was put on, and I know we're reading tea leaves, but because we're in that position, we need to account for every eventuality and possible scenario. I would hate for it to be that the jury that has now rescinded its request for the other testimony has done so because they have now been either browbeaten or convinced of a certain position because they lacked the ammo in terms of Kevin's testimony to retort. So I know that forcing the jury now to read a transcript which they have said they don't need might not be optimal. And so in order to preserve our objection, I would not propose that, but I would move for a mistrial on that basis.
Thank you.
Thank you, sir.
So there's a motion for mistrial and statement to be heard.
I want to make sure I understand. The motion for mistrial is based on the jurors rescinding their request?
That's the way I understand it.
Well, it's based on the fact that we did not provide them the two statements at the same time, and now a request has been made to rescind, the request to see one of them has been rescinded. So it's not the fact that they have rescinded, it's the fact that the court denied our motion to read them at the same time, and now that has resulted in them rescinding the request for one. So that's the basis, to be complete.
Back to my question, statements to respond.
No, not manifest necessity.
Thank you. Motion denied. All right, so what I'm going to do then is, and what do you want to do about the Allen charge? Is it state agreed and the minor state is defending?
We've asked them to print it out so we can look at the Allen charge, if they could, and then we need a few moments to discuss it with the court's permission. I'm sorry.
I'll print it now, if that's okay. I just don't feel like it.
That's all fine, well and good. That's fine. Go ahead. We'll be in recess.
Thank you. Thank you.
I would be a little concerned. And I don't think the prosecution made their case, so I'm actually not surprised.
So, Miguel, with so much evidence to go over, we know they asked for the readback of Trevion Glass, very important character who was there that night in one car, doesn't remember anybody switching cars. That is critical for the defense analysis. They focused on a couple of other minor things, but does that tell you anything when you put that together with this latest question about, hey, what if we can't come to a decision?
Look, I think it seems like it's premature, right? Because we're only about 6 hours and change into the deliberations, and they're already asking a question like that. And they had testimony read back to them. And so I think they need to go back and deliberate more. I think this is premature. And I think there's something to be said about this being Friday and they're sequestered, right? They're not looking forward to not being at home, not having their own life on the weekends. And so they may be trying to see if they can wrap it up quickly, but I definitely think this is premature.
Yeah, I'm confident they're doing their job, but they're humans and they've been at this now for a long time, and enough already. Again, if the initial impression within the group is that we're just not going to come to terms on this. Let's go into court here for the moment in which that particular question from a jury member was asked.
Defendant, this counsel, the assistant state attorneys. So what I was sharing with you regarding the message that Gary advised me was that yesterday when we started, sent the jury to deliberations, Gary asked for all their electronic devices or phones, including smartwatches and Apple Watches. And in fact, one of the jurors has an Apple Watch and presented it to Gary, which he has it secured with all the other electronic devices. Is that correct, Gary?
Yes, sir.
And secondly, he's also indicated that
We're okay with that in total. In total. Facts of the case may truly be. We're fine with that as well. The third paragraph, I don't think is necessary. I don't think it's implicated here. And it says there is nothing to disagree about on the law. The law is as I told you. If you have a disagreement about the law, I should clear them up for you now. That should be my problem, not yours. I don't think anything about any question or any statement the jury has made so far implies that they're unclear about the law and they have a set of jury's instructions there, so we would object to that paragraph. The fourth paragraph reads, if you disagree over what you believe the evidence showed, then only you can resolve the conflict if it is to be resolved. We would prefer that it says only you can resolve the conflict if in fact it can be resolved. The words, if it is to be resolved, that phrase has a certain sense of inevitability, which seems like it's urging them to resolve it. And so we would ask that to be changed to if in fact it can be resolved. The next paragraph we would like eliminated completely. And it says, I have only one request of you by law. I cannot demand this of you, but I want you to go back in the jury room, then taking turns, tell each of the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's view until each of you has had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistrial and will discharge you with my sincere appreciation for your service. I don't think we should be telling the jury how to go about their function of deliberation and suggesting to them that they each get up in turn and give a dissertation as to what they think the weaknesses of their own position are, I think is an unconstitutional intrusion on the function of a jury in its deliberation, and we would object to that. The final line says you may now retire to continue with your deliberations, and we're okay with that. Excuse me one second.
Your Honor, I have a vague recollection of any modifications to that being a problem. I'm trying to read, I believe, it's out of this circuit, 2015 Almeida v. State. I haven't had a chance to read it in full, but I have.
But you're objecting to a change?
Yes, I'm trying to read through, because I know it's.
a modification of the Allen charge, the state's position would be that it should be read in total to the jury as to not comment on what portions or not. I think to isolate certain paragraphs would be truly suggestive and have a negative impact on whatever issue we're having.
Your Honor, I'd like to know if that case that you read concerns jury instructions at large or an Allen charge?
Allen charge.
It is an Allen charge.
Who asked for the modification, the state or the defense?
Probably the defense, but yes, Thomas, the defendant, asked for the Allen charge for the standard jury instruction after the jury deliberated. The standard Allen charge is not given.
And it says that a modification can be or is error.
It says in Young versus State, which is cited in the Thomas case, that the deviation from the standard instruction by one sentence was error.
Okay. So it's all contextual, so we want a chance to take a peek.
Sure.
I guess you don't as well.
Well, this is my question though. The way I read this jury inquiry form, it states, what if we can't come to a decision, question mark. Everyone is stuck on which side they've chosen. That's the question. So, are you telling me, both sides telling me that they interpret that the jury is deadlocked? It doesn't say that to me. It says, you know, what if we can? It doesn't say we can't come to a decision. It doesn't say they're deadlocked.
The second part does. That we're stuck in our respective camps. So that's the declaration of deadlock.
They agree, it's an indication there of deadlock.
So if both sides agree, this is interpreted as a deadlock and they're stuck. Is that what you're telling me? Both sides agree with that?
Yes, Your Honor.
Yes, sir.
Then I'm going to read the Allen charge. I mean, I'm not modifying it. That's a standard that's been around for 40, 50 years. I'm not modifying it. The state objects to any modification. It's not agreed. I'm not going to modify it.
Can we take a chance and look at the case law?
Sure, go ahead.
See whether or not there's some distinguishing language.
I'm going to print comments.
Thank you. Even though Howard didn't say that.
I apologize for this. That's no problem.
We're happy to look at whatever case you want.
Thank you.
1999 for Thomas versus State.
I don't have anything. To the jury, it was as to whether or not the effect of their further deliberations. So in other words, it's giving them an Allen charge and then telling them, and even if you were deadlocked, I'm going to send you home, which is completely different from the substance of the charge itself.
And I think, and at least the way Thomas interprets Young, it's saying that the judge made that error, and that was the judge's suggestion to modify the, and defense objected to the modification. So that's, yeah.
So I don't think I need to speak further to the distinction there, which is the defense saying if the jury is saying they're deadlocked and we've read them Allen charge, and the Allen charge says that if you still can't, case over, sending them back in for another day would be an element of compulsion that would be unconstitutional. unconstitutional, so we could see where that, but we'd like to see if we can distinguish in any other cases. And Mr. Allison wanted me to make this point, which is pertinent, which is that in that case, the defense was the one that objected. Here, the defense is requesting it, so we would have waived our opportunity to object should the court grant our request. Or that explanation was that Thomas. Okay.
Hold on, I'll tell you that tomorrow.
No, I see it in Thomas. I mean, I see it in Young. That's in Thomas as well. It's the same
Thomas
issue.
Sykes, yeah.
Okay. So yes, Your Honor, the Thomas case that the state cited was Thomas v. State, 748 Southern 2nd, 970. It's a 1999 case, Supreme Court of Florida. And that also cites to a state, Young v. State, which is 711 Southern 2nd, 1379, a 1998 case out of the 2nd District Court of Appeals. And the state has represented the issue that Thomas addressed. I'd like to just read some language here from Young that indicates that Young was treating the same issue. In the very second paragraph of the opinion, it says the jury began its deliberations in this case near 5 p.m. on the second day of trial. At or near 9 p.m., it informed the court, quote, as a group, we cannot agree on a verdict, end quote. The trial judge made the decision to give the jury an Allen charge. It is proper for a trial judge in a criminal case to give the standard Allen charge where it appears the jury is deadlocked. The trial judge also decided, however, that he did not want a mistrial that night and would bring the jury back the next morning. So it's the same issue, which is we're going to give you an Allen charge, but it's not going to be effective because if you still can't reach a verdict, we're going to bring you back tomorrow. So it's the same issue in Thomas, and we think that's different from the notion that a Allen charge cannot be modified at all to suit the circumstances of a particular case. Here, I don't think there is any need to tell them about the law because nothing they've said implies the law. And we also think that it invades the province of the jury to tell them that they should each get up one at a time and explain the weaknesses of their position. That is not only counterintuitive to an advocate, and they're advocates for their respective positions. It's counterintuitive to an advocate, and I think it's an unconstitutional invasion of the province of the jury. They should conduct their deliberations and discharge their constitutional function as fact finders without our interference. So we would object.
State, anything else? So let me ask you this, how do you want me to, my thought is, I'm going to handle this question first about who's got a cell phone, if anyone. I'll ask them that as a group, and then I'll read the second inquiry form as what if we can't come to a decision, and then I'll read the jury deadline. I understand the defensive objection to it. The instruction's been around for over 40 years. Stood the test of time.
Thank you, Your Honor.
Respectfully, I'm not going to modify it.
Thank you, Your Honor. I'd just like to read this before the court. I understand the court has made its decision, but Mr. Adelstein brought something to my attention out of the Thomas case, which is a Supreme Court case. And it says, as noted, every Allen charge issue must be decided upon the particular facts and circumstances surrounding an individual case. So that goes to the issue of individuality and whether or not it should be tailored to the circumstances of a particular case. And we're taking a position that mirrors what the Supreme Court has declared, that modification of Allen charges is not foreign. As a matter of fact, the Supreme Court has directed that it should be tailored to the circumstances surrounding an individual case, so that we maintain our objection.
Thank you.
Thank you, sir.
So you want to bring the jury in?
Yes, sir.
Jurors entering. Counsel, the assistant state attorney, and the ladies and gentlemen jury. Ladies and gentlemen, two things. First, I received a note, or my bailiff did. It's not signed by the foreperson, but it's a note that was handed to him. It says, are we allowed to have Apple Watches? Someone has one, from one of the members of the jury. As I tried to explain to you earlier, all the electronic devices are basically, we're not allowed to have those in the jury room, so we asked our bailiff, Gary, to try to collect them. Does anyone have an Apple Watch, yes or no, in their possession? I asked the question, does anyone have one? No? I see everybody raising their hands, or several raising their hands showing they don't. All right, there's no Apple Watches. Thank you. The second thing I want to do is, based upon, I received this juror inquiry form that is signed by the foreperson that reads as follows. State of Florida versus Jamal Demons, case number 19-001872 CF10A. Check the box, ask the following question. What if we can't come to a decision? Everyone is stuck on which side they've chosen, signed by the foreperson. All right? So what I'd like to tell you, or read to you, is an instruction that's called Jury Deadlock 4.1, and it reads as follows. I know that all of you have worked hard to try to find a verdict in this case. It apparently has been impossible for you so far. Sometimes an early vote before discussion can make it hard to reach an agreement about the case later. The vote, not the discussion, might make it hard to see all sides of the case. We are all aware that it's legally permissible for a jury to disagree. There are two things a jury can lawfully do: agree on a verdict or disagree on the facts of the case. Excuse me. There are two things that a jury can lawfully do: agree on a verdict or disagree on what the facts of the case may truly be. There is nothing to disagree about on the law. The law is as I told you. If you have any disagreements about the law, I should clear them up for you now. That should be my problem, not yours. If you disagree over what you believe the evidence showed, then only you can resolve that conflict, if it is to be resolved. I have only one request of you. By law, I cannot demand this of you, but I want you to go back to the jury room then taking turns, tell each of the other jurors about any weaknesses of your own position. You should not interrupt each other or comment on each other's views until each of you have had a chance to talk. After you have done that, if you simply cannot reach a verdict, then return to the courtroom and I will declare this case mistried and will discharge you with my sincere appreciation for your services. Ladies and gentlemen, you may now retire and continue with your deliberations. Step down, Council may roll the defendant. We'll be in recess.
Thank you, sir.
Even a healthy dog should use life jacket because it's more secure for the dog in the water. Even a healthy
I've been smooth for so long, I'm trying to get rough. Buffing my nails, dog, I'm trying to get buff. Shaping my beard up, I'm liking the scruff. The hills, cause I'm living my life in the cut. Can't imagine that I'm gonna meet my wife in the club. We gon' see though, I feel like she more of a CEO. Or maybe she doing volunteer work in Rio. It's not like I need her, but I would love to meet her. Another day, another dollar, another phone with another feature. I don't play goalie, but I'm my brother's keeper. Coaching my family, I'm out with other people. They say I got my pop's demeanor and mother's features. The garden's still private as ever, the gang thriving together. Your boys striving to be the most dominant.
Are you struggling in calculus? Having a hard time understanding your instructor? Do you wish there was a better way?
Either him being a principal or the one who caused the death of Williams and Thomas. It's that simple. Where is the fire? Was the message. They say it refers to guns. That's their interpretation. My interpretation, based upon the evidence, is where's the weed? The marijuana. That's the problem here, folks. They're interpreting it as opposed to calling these various people to tell you what they mean. They mentioned Frederick Gibbons, Frito Bang, Mariah Hamilton, Peasy, Patrick Deloach, Dontavius Withers.
Objection, Your Honor, Halbert.
They opened the door. Stay. We don't have a burden. As the court told you in jury selection, the burden of proof is on the state. And the court told you during jury selection that this is a first-degree murder case, wherein the penalties are either life without the possibility of parole or death. You folks are going to determine this young man's fate. And they come in here and give you alternatives. They come in here and give you their interpretation when we don't have to do a darn thing. And that principle was so important that His Honor read you that instruction at the beginning when you were going through the process. That he just read it to you before the state got up and gave their opening closing statement. He told you that this young man has pled not guilty. That means you have to presume him innocent. That means that that presumption stays with him until and if the state of Florida can prove their case beyond and to the exclusion of every reasonable doubt. The judge goes on to tell you, and it's in your packet of jury instructions, that the defendant, YNW MELLY, is not required to present any evidence or prove anything. So it's nice that they're interpreting these things, but the bottom line is they don't even know. Because they've given you just two alternatives. Either he's the shooter or the principal. Make up your mind. Tell these folks what it is. Now, how do you go about doing this? Well, the judge gave you an instruction on that. You're to look at the evidence that's been presented to you. Remembering, we don't have to do a thing. All we have to do is show up and behave. Now, I don't know if I behaved totally correct during the course of this trial. So, on behalf of us, let me apologize if I have, or we have, offended any of you. And I would ask you, I would plead with you, if I or any of the other individuals have done anything to irritate you, don't take it out on this young man. Still hold the burden of proof to this table. Now, why do they have the burden of proof? Because they are the state. They are the government. As we learned in this case, they have the police department of Miramar. They have the Broward Sheriff's Office. They have the DNA labs. They have experts, the FBI. They have everything at their disposal. And that's why our system of justice is different than anyone else in the world. We recognized a long time ago that when the government accuses somebody of a crime, they have the money, the resources, and the person power to attempt to prove to you all that a person has committed a crime beyond and to the exclusion of every reasonable doubt. Now, how do you go about doing it? And before I get into that, first of all, let me also thank you, because we have interrupted your lives for it seems like months. And we have put a horrible burden on your personal lives, your family life, and what have you. And all of us applaud and thank you for your service. You folks have gone way beyond the call of duty. And I think we all recognize that. But how do we go about determining, and I shouldn't say how do you folks go about determining if the state of Florida has proved their case beyond and to the exclusion of every reasonable doubt? Well, the judge just gave you that instruction. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. Remembering, we just got to show up. And how does a reasonable doubt occur? Well, the judge has told you. It can come from the evidence itself, a conflict in the evidence, or a lack of evidence. You don't need all three of these areas. But I suggest to you folks that we have a reasonable doubt from the evidence that has been presented, that there is a conflict in the evidence, and there's a lack of evidence. This is an unusual case, kind of like the medical examiners. The two medical examiners said it's unusual because normally you can't tell what shot occurred first, second, and third. And the chief medical examiner came in here, Dr. McDougall, I think, and told you it's only happened to her in her entire career, I think 2 or 3 times, that she could tell you which shot occurred first in this case. So, knowing that, let's look at what the state presented. But before we do that, we can agree upon a couple of things that are not in dispute. They said that Matt Melly is a talented music artist. We agree with that. At the age of 19, based upon the evidence, he was making more money than probably everybody in this courtroom, including us. Number 2. Oh, I'm sorry. I apologize. You okay? Usually the judge will stop me immediately. Number 2 is that Cortland Henry changed his clothes before he went to the hospital. That's what they said just 10 minutes ago. Number 3, that there is absolutely no eyewitness implicate this young man to this crime, these crimes. Number 4, they talk about premeditation. I suggest to you there is absolutely no evidence whatsoever to show premeditation. And the last one that we absolutely agree with, and they admit it, the Miramar Police Department lacks the training. Those aren't my words. That was Miss Bradley just an hour ago saying. Not only did Miss Bradley say that, but Sergeant Williams also said they lack the training in one of the worst investigations. That's why I pushed aside their reports. Now, the state produced over 100 exhibits sitting right here on the floor. Ms. Bradley made reference to some of them. They're all here. And I put them on this side of the podium because I suggest to you that this is a smoke screen. I suggest to you that this is open for anybody to interpret any way they want. When I say something sarcastic, you don't know if I'm serious or not. I can tell my colleague, I hate your guts, and it could be joking, and I am joking. And that's what this case is, and that's all this evidence is open for interpretation. That's not evidence proof beyond a reasonable doubt. Now, I put on this side of the table really the evidence that means something. There's one other exhibit, but it's on a little USB internet thing. And that is the video leaving the studio, showing the 2 cars and the 8 individuals that left. Sitting on this side of the table is a broken cell phone that Moretti could not tell you whose it was, and the 9807 phone that Melly uses, as other people do too. These are the 2 key pieces of evidence. These are what I suggest you focus in on, because you can take any one of these items, any one of these text messages, any one of these pinging on maps, and you still don't know what was said, what was meant, and more importantly, who said it. I leave my phone, and I'm sure you all, in the house, and my wife picks it up and sends a message. And it looks like it's coming from me. And sometimes she sends messages that I'm kind of shocked about. But you don't know. So let's put the 100+ exhibits to the side for a moment. The state called 26 witnesses. I think I counted. And I suggest to you that you should look at 11 witnesses very carefully. And why do I say that? Because when you look at these 11 witnesses, you will find out that there's a conflict in the testimony, that there is a lack of testimony, and the third way is from the testimony itself. The first one that I would like to talk about well, before I talk about the first witness, I want you to remember one thing. On October 26th, that day of the shooting, we learned immediately that that Jeep was taken to a secure area. And it was searched for over 15 hours by 2 crime scene technicians. And you heard how they pulled out the evidence. They some foam, some projectiles, I think a can, everything, and photographed the vehicle. Now, why is that important? Because that vehicle was searched. You okay? You want to take a break? That vehicle was searched again months later. But it didn't stop there. Because about 3 years later, miraculously, even though it was searched for hours by crime scene technicians, Sergeant Williams comes into the scene at the request of the state of Florida, this particular prosecutor right here, and miraculously he finds additional evidence, 2 projectiles and a bloodstain that obviously everyone else missed. That should tell you something about the quality of this investigation. That should give you a clue as to what's going on in this case. What happened was, once they got the surveillance tape of individuals leaving the studio, they knew that Cortland Henry, Williams, Thomas, and this young man got into the Jeep. It's shown on the video. In the Mitsubishi were Adrian Davis, Patrick DeLoach, Trevon Glass, and I'm missing one other one. Pardon? Withers, Dontavius Withers. And we know that on October 26th, when Moretti saw that surveillance, Cortland Henry identified all of them. And in fact told them that he lives at this young man's house I made a mistake. Jacoby Mills was in the car. It was Jacoby Mills, Adrian Davis, Trevon Glass, and Dontavius Withers. Okay? I can't keep the names straight. I'm lucky if I can remember my own name. That's why I haven't written it down. We know that Moretti identified all 8 people that left the studio on October 26th. We also know that Moretti knew where this young man lived, along with all the other 7 people that left the studio. We all know that, according to the state, Cortland Henry lied to the police. And we also know, as the investigation progressed, that Cortland Henry had blood matching the victim on his clothes. And he also had GSR, or gunshot residue, on his clothes. If that were true, and you saw the pictures of the Jeep, all bloody, blood all over the place, and we learned that you could spray and determine if there was blood right here on the carpet, even though you don't see it, why in the heck don't you get a search warrant for the house? Why in the heck don't you? Don't tell us we didn't know where he lived. Don't tell us it was months later, because they go into the car 4 years later and do this. So why don't you do it? Because Detective Moretti and the Miramar Police Department, as as everyone has said, lacks the experience and the training. We don't have to do a darn thing, folks. We don't have to do a thing. But let's go into the 11 witnesses now. The first one, and they mentioned him, George Bello, the manager, the head guy. Of the gun and tool mark unit of the entire Broward Sheriff's Office. And he tells you, after we get a great education of guns and projectiles and casings, we have to bring out the fact that can you tell or determine the distance between the shooter and the victim? Can you tell us that with all your experience? And what does he say? I can't do it unless I have the weapon, unless I have the ammunition, because ammunition, the weight of ammunition could change the distance. And you have to have the weapon in order to do that. He cannot even tell us if it was one gun, two guns, or more. He's honest. He tells you that without the weapon used, I cannot place the shooter to the victim, or victims in this case. Now, why is that important? Because a reasonable doubt can arise from a conflict in the testimony. If you believe George Bello, and I suggest you should, then he totally contradicts all the testimony of Sergeant Williams, who comes in here 4 and 5 years later and says, I can tell you where shooter one was, and I can tell you who the shooter is. You talk about a conflict in the testimony? It's one or the other. It can't be both. And he tells you, in addition to that, that the environment has to be considered. Now, Williams tells you he goes out to the scene some 4 or 5 years later and has no idea, nor did he even check the terrain, the environment on that particular morning hour. So you got to believe one or the other. You can't believe both of them because they are in direct conflict with each other. But let's go further. The next witness that you should consider is FBI agent Brendan Collins. He is an expert in tracking phones. He is not only an expert in Broward County, but he's an expert, and his team have been specially trained to map phones, not only in this country, but anywhere in the world if he's called upon. They brought him in. And what does he tell you? This expert. I cannot determine precisely the location of a phone. I cannot say 100% the phone is in, and you saw the band, it looks like a banana. He says, I think it's somewhere within this area, but I can't be 100% sure.
Evans, this counsel, and the assistant state attorneys. The jury is in the jury room. I have another question or juror inquiry form that says, ask the following question. Ray, exhibit 116, times listed.
This is a switch bike. This is a switch bike. No, this is a switch bike.
In fact, any bike can be a switch bike.
And we mean any bike. All you need is a switch kit. It's lightweight. Pocket size. Connects to.
You can answer yes. No, I think we need to just settle for rely on the recollection of the test.
I don't have an answer. I agree. So,
yes.
counsel, I just answered this way. So you are to rely on your recollection of the evidence tonight for my initial. All right. Any objections? No?
No objection, sir.
Thank you.
Thank you.
We're in recess.
Recess.
It's time for me to get set up for therapy, and I use this room as my office. But the desk is over here, and so when I'm seated at the desk, this is the background. I have my therapy session, which is virtual, and I find myself looking really forward to it nowadays because I found a therapist that I really like. I had to switch a few times until I found one that I loved, but now I look forward to it a lot. So gonna hop on that, and I will catch up with y'all in like 30-45 minutes. Let's talk about therapy. I've been using BetterHelp for the last 3-ish months, and to make it more accessible and affordable for people, I think is pretty necessary. I have loved how easy it is to schedule. I mentioned at the beginning of this vlog that I went through 3 therapists until I found one that really stuck and clicked for me. And I think that's normal. Therapists are people. We are people. We have to communicate in a way that we get each other. And they made it so easy to get a new therapist and see which one fit for me. You go online and you kind of like say what you're looking for. Also, like, I prefer male, female, I prefer faith-based or not, all these types of things. And they have over 20,000 therapists online. And so you have access to some that you might not otherwise be able to meet with in your immediate area. And something else that
and say it's proof beyond and to the exclusion of every reasonable doubt? I guess so, according to them. And they call Danny Benitez. Who the heck is he? He was on the stand for all of about 2 minutes. Danny Benitez gave Detective Moretti the surveillance tape from the Montessori school. You watched it. It showed, I suggest, nothing probative to implicate this young man in it. But we learned, not from him, but from Moretti, that he doesn't go to the drugstore on Miramar Parkway to check their surveillance tape. He doesn't go to Applebee's to check their surveillance tape. He doesn't go to Polo Tropical or the gas station or the bank on Miramar Parkway to check their surveillance tapes. When the car's on 184th Avenue, he doesn't go to the fire station to check their tapes, surveillance tapes. Doesn't go back to the 2 elementary schools, Sunset Lakes and West Broward Elementary, to check their surveillance tape, because he knows it all. He knows it. How do you know it if you don't check? How do you know something unless you investigate? We don't have to do a thing, folks. We don't have to do anything except show up. And begrudgingly, we did. Where the Montessori school was, on Pines, there was a tractor supply company and another school. Why don't you get that? And come in here and say, you know what, folks? We checked all of this. Instead, what they do is take a helicopter ride 4 or 5 years later. And we have to sit here and watch as they fly the route. And we have to watch how they drive the route. Not checking what the traffic conditions were that day, back 4 or 5 years ago. Not checking what the weather was 5 years ago in October 26th. What's the purpose of that? Just to add more of what I suggest is a smokescreen. You look at all this and say, heck, man, 100 exhibits, 500 photographs out of a cell phone, all these text messages. What does it mean? Hopefully, for the state, you'll say, hey, where there's smoke, there must be fire. And say, hey, too bad, young man, too bad. There's a lot of stuff sitting here. And hopefully you will not fall into that trap. And then we get to the lead detective. Well, before we get to the lead detective, I think I missed someone. Trevion Glass, the individual who got into the red Mitsubishi. The man who is convicted of 2 felonies. Now, why is that important? Because the judge read you an instruction on some of the factors to look at in determining whether or not to believe a witness or not. And he told you that one of the factors to look at is whether or not the witness has been convicted of a crime.
apologize.
Who would open the door?
I normally open it for Lou.
Make sure we're all in the same place. Everybody agrees?
Yes, sir.
Yes, we're all good?
Yes, sir.
All right. So can I bring you back in now then?
Yes, Joe.
Yes?
Yes, sir.
Yeah, do you think, I forget whether we did during trial, do you need a light
Yes.
gift or not, yes? All right, so you want to bring the jury back in? Yes, bring it back up.
You cold?
Ladies and gentlemen, thank you. Please be seated. Let the record once again reflect the presence of the defendant, his counsel, his assistant state's attorney, ladies and gentlemen, the jury. Ladies and gentlemen, I have a question of evidence here. It says you requested the traffic video from 595 to see what time the Jeep and Mitsubishi passed the express lane cameras. We attempted to pull up the footage on a laptop, but it would not play. I've asked counsel to secure that portion of the evidence for you, and it will be replayed for you now. You ready, counsel?
334:53.
Yes. Defense, yes. Does that complete the publication?
I believe so.
Thank you.
Thank you.
Thank you, ladies and gentlemen. You can go back to the jury room. Continue with your deliberation. Thank you. Let the record reflect the jury stepped out. Counsel remain along with the defendant. We're in recess.
How long does it take to upgrade?
My head is spinning from all this rave. I can't move my
Tyson Air Fried Chicken. 75% less fat, 100% delicious. Only from Tyson.
understanding from talking to our bailiffs is that because of the sequestration, they need to take the jury to the hotel, otherwise they missed it or something like that. It's 5:15, you said the latest. So it's 5 or 10 minutes from now, and well, less than 5 minutes from now. In any event, what I want to confirm with you again is that they're going to take the jury. They'll excuse them now. There's no need for me to bring them back in the courtroom, correct? Correct.
Yes, sir.
So they'll just take them to the jury room, excuse me, to their hotel room. They'll feed them tonight. They'll make their phone calls as they typically are done. They make phone calls and stay observed and things like that. And then they're going to be back here after breakfast tomorrow morning. They'll be back here.
Between 8:30 and 9.
Between 8:30 and 9. Again, my question is, can I do it like today, where you're the attorneys are not involved in it? You know, we'll call you when we need you, and the bailiff just puts them back in the jury room, and you'll be on, let's say, a half-hour notice. Is that good for everybody?
That's good. You okay with that? That's good.
Yes, Mr. Dennis? You understand?
Yes, sir.
You think this easy? You got to be able to gangster walk on the ceiling.
And Gary, you're going to be here tomorrow, right?
Yeah, that's good.
Do you have all the phone numbers?
Yes, I do.
All right. So if something happens, are you going to be here tomorrow morning, or you'll be here? No. Okay.
We'll be here. I'll be here.
All right.
I ain't slow, Judge.
All right. Well, I know you were here this morning early, and then you had to run this delivery, but you were here first thing. But in any event, we'll do it the same way, and your co-counsel, they'll get here within a half hour. All right?
Yes.
He's on his way.
All right, counsel, is there anything else to discuss then?
Yes, sir. Thank you.
All right, thank you. It's 5:15. Tom, you want to take
Yeah.
us in? All right, we're adjourned for the day.
I think you guys. Yep. Sorry. Good day.
Wesleyan University.